sexual orientation discrimination first. Same-sex couples have been able to enter into civil partnerships, as you know. It's actually since the 5th of December 2005. And so discrimination on the ground of being a civil partner has actually also been unlawful in employment law since that date. And that brought civil partnerships into line with marital status. And civil partners, of course, are also potentially covered by the discrimination on the grounds of sexual orientation legislation. But under the Equality Act 2010, employers and pension scheme providers don't incur liability for sexual orientation discrimination against civil partners in respect of benefits that actually accrued before the 5th of December 2005, when civil partnerships didn't exist. Now, that's the point that was taken in this case, Innospec Limited and Walker, where the EAT had to consider whether a pension scheme that provided survivors' benefits to spouses, but not to civil partners, was discriminatory insofar as those benefits derived from the period before the 5th of December 2005. And they decided that, perhaps this is controversial, but they decided that although the scheme's operation was actually discriminatory, both directly and indirectly, that discrimination hadn't been unlawful in respect of the period in question and shouldn't be therefore applied retrospectively. The case is actually going to the Court of Appeal in May or June of this year, so if it's something you'd be interested in, and you take our employment newsletter, and if you don't, do sign up, we will let you know the result of that case then.
Okay, so we're going to have a quick look at compensation before we then move on to age discrimination. A claimant who has suffered discrimination and/or harassment is entitled to claim compensation for injury to feelings in addition to loss of earnings. And the level of compensation is determined by reference to what is known as the Vento Guidelines. And these are three broad bands of level of compensation for injury to feelings, which increase based on the severity of the injury. And they were set down in the case of Vento and Chief Constable of West Yorkshire Police. The amounts in these bands have been increased over the years to take account of inflation. So moving on to our next case, the Cadogan Hotel Partners Limited and Ozog. Ms Ozog was employed as a waitress at a hotel which was owned by the company. In June 2012, the head waiter kissed her hand, touched her hands and back, and asked if she had a boyfriend. In another incident, and in the presence of a female colleague, he took off his trouser belt and propositioned her.
Well, Andrew did tell you employment law was sexy, didn't he? It sounds like another scene from 50 Shades of Grey to me, Marie.
How would you know, Brian? Ms Ozog later complained to her supervisor and a manager, and also alleged that he'd been bullied and threatened her. Following a dispute about Ms Ozog's work performance in July, she resigned by email. But before doing so, she complained again about the head waiter's behaviour, but none of her complaints were put in writing.
Well, perhaps not surprisingly on those facts, the Employment Tribunal did uphold Ms Ozog's claims. The question was how much they were worth in terms of compensation. It found that the touching and kissing incident was a mild form of sexual harassment, which had made her uncomfortable, these are all quotes, and that the belt incident had made her very uncomfortable. And then they decided to award her £10,000 in respect of injury to feelings, taking the view that the award fell just below the halfway mark of that middle band of the three bands that Marie referred to, which extends from £6,000 to £18,000 compensation. And then the tribunal did something else. It increased the award by 25%. On the basis that the company had, they said, failed to comply with the ACAS code on discipline and grievances because it had failed to investigate Ms Ozog's grievances. Well, the company appealed, and the EAT has actually reduced the award for injury to feelings from £10,000 and taken it down to £6,000. And its reasoning was as follows. It said that Ms Ozog had suffered one incident of harassment which made her feel uncomfortable, and one isolated incident which made her feel very uncomfortable, and that on that basis her injury to feelings should be calculated within the bottom of the Vento bands, although towards the top of that band. They also held that as the ACAS Code of Practice on Disciplinary and Grievance Procedures actually requires an employee to put their grievance in writing, that there wasn't any breach by the employer by reason of the failure to investigate. It wasn't that they didn't need to investigate, but the 25% uplift didn't apply.
Where loss of earnings suffered by a claimant is only partially caused by the discrimination, the tribunal can apportion the compensation accordingly. And this is what happened in our next case, Malcolm and Dundee City Council. Miss Malcolm is a devout Christian, and she complained that, among other things, male technician colleagues at Baldragon Academy stuck models of a, how can I put this? Part of their male anatomy made out of blue tack to her telephone. They also scribbled male genitalia on drawings she'd done for her brownie pack. They also used what the Employment Tribunal described as coarse industrial language in front of her. The Employment Tribunal found that the technicians had conducted a planned campaign against her, which went on for 7 or 8 months, and unsurprisingly, they said that amounted to sexual harassment. Unfortunately, her mental health suffered as a consequence of her treatment, and she was unable to work.
Well, the Employment Tribunal awarded her £25,000 on this occasion for injury to feelings. They also awarded £12,500 for psychiatric injury, and they ordered £25,603 to be paid to her for loss of earnings. Now, in calculating the compensation payable to her, they then reduced the loss of earnings element by 50%. And they said that the reason for that was that she had a history of psychiatric illness already, and that her absence, therefore, couldn't be said, her sickness absence, couldn't be said to be wholly attributable to the harassment to which she'd been subjected. That went to the AT, and they confirmed that the tribunal had been right to do that.
So the practical message that we want to take away from this case is, as we've already mentioned in other contexts, however dire the circumstances of a claim, there are often arguments that can be made to try and reduce any compensation that's awarded to an employee or former employee.
Right. As you can see on the slide now, we're turning next to a very, very important area of employment law. In fact, I think it's difficult to overemphasize how important this area really is. It's hugely important. Age discrimination. Now, direct age discrimination occurs where one person is treated less favourably than another because of their age. And it's no defence for the employer to say, oh, I didn't intend to discriminate. And in this case, Ms. Reynolds was engaged by an insurance firm as a consultant, chief medical officer, so not an employee, a consultant, but still covered by the Disability and Age and other sex discrimination and everything else in the Equality Act. So, while some aspects of her performance were highly regarded, senior members of the administration, senior managers there, had serious concerns about her. And in late 2009, the managing director prepared a report. He put it before his colleagues in February 2010 and identified a number of things that he felt were unsatisfactory about Ms. Reynolds' performance. He said there was a need to chase her up, to follow cases, that she didn't handle paperwork very well, that she lacked focus. And the conclusion was that the service provided by her was simply not consistent with modern-day claims handling needs and the commercial pressures faced by insurance companies. And as a result of that report, it was put up the line to the UK General Manager, and he decided that he just couldn't have her continuing to be a consultant and terminated the arrangement with effect from 31st of December. No attempt was made to address the performance concerns on the basis that he didn't believe that Ms. Reynolds would make any changes if asked anyway. Why is this an age discrimination case? Well, because Ms. Reynolds was 73 when all this happened, and she claimed that the termination of her contract was an act of age discrimination.
The Employment Tribunal rejected Ms Reynolds' claim. Whilst it was satisfied that no attempt had been made to address her performance issues and that her age had been mentioned in discussions about her future, it was satisfied that the general manager who actually made the decision to terminate her contract was genuinely motivated by the deficiencies in her performance and not by her age. This was appealed, however, and the EAT decided that the tribunal was wrong to focus solely on the motivation of the individual manager who was responsible for the termination of the contract. It said that the tribunal should have considered the mental process of other managers who had materially influenced the decision. So, what does this case tell us? Well, it emphasises that just because the person making the final decision to terminate didn't intend to discriminate, it doesn't necessarily let the employer off the hook. A tribunal should also consider whether the decision was sufficiently influenced by others for their motivation to be part of the reason for the treatment complained of.
Unlike other discriminations under the Equality Act, direct age discrimination can be justified by an employer. And last year, in these two German cases, the European Court was asked to consider whether a pay scheme in which civil servants in Germany starting grades based on their age, whether that was justified. The court considered that it wasn't. But they did actually say that a transitional pay system, which to some extent perpetuated that discrimination for existing employees while removing it for new ones, was justified, because it had the legitimate aim of protecting the acquired rights and legitimate expectations of the existing civil servants and their concerns to protect their future pay progression. Had the new pay system been applied to the existing civil servants, many of them would have suffered a drop in pay. And also, when the new system was being negotiated, the trade unions, which were very strong in Germany, had insisted on the preservation of the acquired rights of the existing civil servants, and the view was expressed that if the employer hadn't made those offers and hadn't given those guarantees, it would have prejudiced the chances of the new system being negotiated at all. Now, we find this decision actually rather out of step with the way similar cases have gone in the UK on equal pay, for instance, where trade unions have sought to protect, particularly in the public sector, sought to protect the discriminatory, unequal pay of male employees, male members of the union, saying, well, it won't be acceptable, it's unfair, etc., to reduce them so that they are paid the same as women and take away particular benefits, for instance. The courts, all the way right up to the Supreme Court, have said we don't accept that as justification in the UK. But in the German civil servants case, it was accepted.
One area where employers commonly use age as a differentiating factor is when calculating enhanced redundancy payments. Typically, such schemes must be objectively justified if they're to avoid amounting to age discrimination. However, there's a provision under the Equality Act that provides an employer does not discriminate against an employee because of their age if the employer does anything that it's obliged to do by legislation. And we sometimes hear this referred to as the statutory authority defence. In Heron and Sefton Metropolitan Borough Council, while employed by a central government agency, Ms Heron was covered by the Civil Service Compensation Scheme in accordance with the Superannuation Act 1972. The terms of this scheme included a formula for employees made compulsory redundant, which capped the redundancy pay at half a year's pay for the over 60s. When Ms Heron's employment transferred to the council under TUPE, it was no longer covered by the Act, but the terms of the scheme became incorporated into her contract. She was made redundant, and she claimed age discrimination when, because of her age, she received a considerably lower redundancy payment than her younger colleagues.
Well, the council tried to rely on this statutory authority defence. They pointed out that they'd inherited the civil service claims, they'd become part of Miss Heron's contract, and that there was therefore a contractual obligation on them to comply with them. However, Her employment with the council wasn't covered, as Marie said, by the Superannuation Act 1972 once she had moved jobs. So it was found that there was no statutory obligation on the council to follow those terms, only the contractual one. Unfortunately for the council, it also failed to objectively justify its application of the terms. So Ms Heron's claim for age discrimination was upheld. Now, you might think, some of us think, that this decision was rather harsh on the council because, after all, they were simply complying with the terms of the employment contract. It goes to show that it's important to review your terms and conditions regularly, and particularly if you're taking on new staff under TUPE. We do, just in case you were wondering, we do offer a risk audit service which includes reviewing all your terms and conditions and policies and all the rest of it. And Marie would be delighted to have a chat with you at lunchtime if you're interested.
Thanks, Brian. Right. It's common for permanent health insurance schemes to cut off provision of cover once employees reach a certain age. And questions have arisen as to whether an employer might need to foot the bill for continued payments beyond the cut-off date. In Whittam and Capita Insurance Services, the Newcastle Employment Tribunal held that Capita was guilty of age discrimination when it stopped paying an employee benefits under a PHI scheme at the age of 55. It was no defence that they only stopped making the payments because the payments under the insurance policy had come to an end. The employee had also been prevented from transferring to a more favourable scheme which made payments up to the age of 65, as the company required that only employees who were actively working and not already in receipt of benefits could transfer. The tribunal said that the application of this criterion amounted to indirect discrimination, which couldn't be justified as the employer's reason for applying it was purely to save cost.
Right. This is a case that you may remember from previous years because it's been going on for a long time. I think I wanted to call really for a minute's silence for Mr. Selden because poor Mr. Selden was the senior partner of a firm of solicitors with, it's a very sad case, senior partner of a firm of solicitors with offices in Orpington, Tunbridge Wells and various other locations in Kent. I don't apologise for mentioning it one last time for all sorts of reasons, but also it's now finished. It's the last chapter has taken place in the last year, so we need to bring it up to date. But it also could have wider implications, which I just want to explore. Now, just a reminder in case you don't remember, Mr. Selden, poor Mr. Selden, he was the victim in some ways of his own efficiency. He had presided over the production of a partnership deed, which stated that equity partners would automatically retire on reaching the age of 65. Now, at that time, of course, the firm also operated that rule for its staff. Everybody had a normal retirement age of 65. As you know, the statutory default retirement age of 65 was subsequently abolished. The government decided that it couldn't be justified as a matter of law, and they repealed it. Now, when Mr. Selden reached the age of 65, his fellow partners decided to enforce the term of the partnership deed, which he had freely entered into, and he claimed this was age discrimination, which of course it was. There isn't any argument that it was. The issue was whether it could, as a matter of law, be justified. And as we mentioned earlier, age discrimination, direct age discrimination indeed, can be justified.
So this case has gone backwards and forwards between our own courts in Europe, going all the way to the House of Lords, who ultimately sent it back to the South London Employment Tribunal, where it started 8 years ago. The sad news for Mr. Selden is that in the end he did lose his case. The firm could justify making partners retire at 65 for the legitimate purposes of staff retention and workforce planning. If partners stayed on indefinitely, the scope for promoting new partners would be reduced. The firm were able to satisfy the tribunal that in the particular circumstances of their case, this was an issue. Mr. Selden also failed in his argument that 65 was too young. The EAT acknowledged that a narrow range of retirement ages either side of 65 could equally have been chosen, but this didn't mean that the age of 65 couldn't be justified.
So that's the end of Mr. Selden's case, but what does it mean for employers generally? Well, the commentators point out that there are particular circumstances in this case. Mr. Selden was the partner who had actually freely entered into and promoted the partnership deed, which he'd signed. They also pointed out that actually it may have been a factor in his case that at the time his case first came before the House of Lords, the default retirement age for employees hadn't yet been abolished. That happened afterwards. This case goes back a long time. So he was asking at the relevant time for more favourable treatment than his employees and employees generally. In principle, however, I think what we have to accept is that the case does open up the possibility of an employer reintroducing a compulsory retirement age if it felt it needed it for staff retention and career progression. Now, it would be hard for many companies, I think, to prove that case, but it is by no means impossible, and in law this case shows that it is possible. I wonder how many people here, did you just get rid of the reference in employment contracts to retirement at 65 when the law changed? Is there anybody here who's still got retirement at 65 or indeed at any age in contracts? And does anybody think actually that they might be able to justify it, that they miss it and feel that it is something that they wish they had? No, nobody. Well, there you are. That's interesting. We've all lived with it and are quite happy for people to carry on as long as they want. Right. I think it's highly admirable. Well, last word from Mr. Selden. He may have lost his claim, but he does have the distinction of giving his name to a leading case in the law reports, which for a lawyer will be a huge consolation for him, I'm sure.
So finally, we're going to have a quick look at victimisation. In order to succeed in a claim, an individual must show that they have suffered a detriment, essentially some kind of disadvantage, because they've done a protected act. A protected act can involve them complaining of having suffered unlawful discrimination, for example, if they raise a grievance or make a claim. It can also cover situations where they've assisted somebody else, so they might have acted as a witness in a claim or as a representative or a companion. There has to be a causative link between the protected act and the disadvantage suffered. If the disadvantage was actually suffered for another reason, for example because of absenteeism or conduct, then clearly a claim of victimisation could not succeed.
Last topic is about post-employment victimisation. Post-employment victimisation means victimising somebody, treating them unfavourably after their employment has ended. That's the post-employment bit. And the victimisation means that it's because they have done a protected act, as described by Marie a moment ago. Now, this wasn't actually specifically mentioned. Post-employment victimisation wasn't specifically mentioned when the Equality Act 2010 was passed. So there was some doubt about whether actually it was prohibited in law. But the Court of Appeal has now confirmed in the Gotelee case there that post-termination victimisation is also unlawful and can be the subject of a claim. The most common situation in which people claim post-termination victimisation is when, say, they receive a bad reference after they've made a complaint of discrimination or supported somebody else's claim of discrimination. Best advice if you're asked for a reference by somebody in that situation is don't do that. Don't give them a bad reference. If you feel you can't give them a reference, don't give them a reference of any kind. Otherwise they'll say it's because of the Protected Act. We've also had a case called Onu and Akwiwu. Ms. Onu brought a number of claims against her former employer, Mr. Akwiwu, which included failure to pay the national minimum wage, direct race discrimination, indirect race discrimination, and on top of that, harassment. And having been in receipt of those claims, he telephoned Ms. Onu's sister in Nigeria and said that there would be trouble if she continued her various tribunal claims against him. She claimed victimization for obvious reasons, and in a rather bizarre decision, actually, the tribunal decided that her claim should be dismissed because it wasn't clear that he'd made the threat via the sister because of her protected act, since he hadn't specifically referred to those parts of her claim which were discrimination or harassment, as distinct from all her claims, which included minimum wage and other matters, which aren't protected acts. So not surprisingly, that went to the Court of Appeal, and they said that was wrong. Where somebody has brought a discrimination claim and they are then subjected to unfavourable treatment, the link will readily be made between the two. The person doing the victimising doesn't have to be stupid enough to say, this is why they did what they did. The tribunal won't look too hard for evidence of the causal link.